We had a great response the first time we showed this, and that makes us happy because dreamers are a big part of our heart, and we want to be able to pass on information. Um, this is also part of a series of webinars that our firm has been presenting. My partner, Maricela Alvarado, presented a presentation regarding DACA and different options, family options. This particular presentation is going to address what is it that a dreamer can do when there is not a family-based option, okay? And so that's what we're going to be talking about today. And again, this is just introducing information. The idea is you're not supposed to go out and try to do this because you're going to learn throughout the presentation is that the government is not quite ready to process these cases yet, okay? But let's hope that you can learn a bit about the process, and maybe you can get a few tips for those of you who really can't depend on a family-based option, okay? So anyway, welcome. And again, the people that will probably be out there looking at this are dreamers that aren't eligible for family-based petitions, okay? DACA recipients with U.S. degrees and working towards U.S. degrees, okay? That's going to be an important group as well. Dreamers working with U.S. degrees and working towards U.S. degrees. Okay, there's a difference between a DACA recipient and a dreamer. We're going to kind of break it down for you as well. And here, employers. Employers are the ones that we are really anxious to see this, because you would be surprised. You would be surprised at how many employers are really out there. They are keeping up with this matter. They really like their DACA employees, and they want to do whatever they can do to help support them finding legal status, okay? We also have in our audience some people that are working with universities who are serving dreamers and DACA holders, okay? So welcome to all, and we're going to go ahead and be moving forward and seeing what is it that we've got going on, okay? Okay, this is the reality. There's a continued threat to DACA and DACA advanced parole, okay? You know, without trying to get political in any sense of the word, we do know that we're looking at the possibility of a second Trump administration. And it was actually the Trump administration that first closed up DACA, okay? They rescinded the 2012 DACA memorandum, and that was in September of 2017. A new president may try to terminate DACA and eliminate DACA advanced parole, which is an essential safety net for DACA beneficiaries who travel abroad to apply for H-1B or other non-immigrant visas with a D3 waiver. Alternately, there is some hope. There is some hope that maybe the Supreme Court might help us. I know the last hearing they had a few weeks ago did not go as bad as we thought it would. So there might be some hope as well there, okay? But the case challenging the legality of DACA policy is currently under review, and so we're waiting to see what happens, but we don't think things are going to go well. So it's always, it's always good to be prepared for the worst and to start looking at your options, okay? So this is a reality, and this is one of the reasons that we're presenting this presentation today, okay? Earlier in the year, this summer started with lots of hope. President Biden announced new actions to keep families together, and that was in June 2024. Goodness, it feels like if it was just months and months and months ago. But he announced two new initiatives, okay? One, keeping American families together. And in that option, what he introduced was a way of basically filing adjustment of status without the need to having to leave, process the visa abroad, and so forth, right? Unfortunately, that's under challenge. Biden's Parole in Place program for spouses of USC went live August 19th, 2024. And 8 days later, on August 26th, um, the case was challenged. And so what has happened is they are accepting applications, but there is a stay, and we don't know what's going to happen with that. Okay, we really don't know what's going to be happening there. The other thing that he announced was easing the visa process for U.S. college graduates, including Dreamers. Now, I really, really got excited about this option. And the reason I got excited about this option, because this is describing a part of the immigration law that actually exists. It's not something that, all respect to President Biden, that he was making up, like the parole in place. Okay, this is actually a visa. It's a waiver. The D3 waiver is a very powerful waiver. It can take away or pardon inadmissibilities, such as unlawful presence, such as unlawful employment. Okay, so this is actually something that the Biden administration said they were going to try to streamline, to make faster. Currently, these waivers are taking over a year to adjudicate. And so we normally see this in people who are trying to apply for a non-immigrant visa. They come and, they've committed some sort of immigration violation. So what they do is they come to the US. They go to their consular post and they present a visa application and see if the consular officer would consider a D3 waiver, okay? And this waiver is, we're going to go into more detail exactly what is required a little bit later, but it's a powerful waiver. And let me tell you, the first time I ever used it in my career, it was a case of there was a school, and this school took basically about 30 kids outside of the US. These kids were all under 18, and they took these children outside of the US. Well, they weren't really children, they're like high schoolers, maybe high school, early college. And what they didn't realize is when they took these people out of the US is that many of them were dreamers. They didn't have work authorization, okay? They didn't have status. So they took these kids, they took them out of the country, and suddenly, guess what? 3 and 10-year bars, these young people were facing not being able to return back to their home countries for at least 10 years, because that's what the rule is, right? You leave after being here in the US for at least 1 full year, and you leave the US. So what happens? You can be facing a 10-year bar. So this is the first time that I worked with D3 waivers. We worked with, goodness, we're helping to bring 15 young people back into the US. And it was a special circumstance, but I was able to see the power of it. And this is something that actually exists in our immigration law. This is something that they can't take away from us. DACA can be challenged because that's an executive order. But this is part of the existing immigration law, which is actually the D3 waiver, which we're going to be talking about in more detail. Okay, so that's why I was excited in June earlier, because there was an initiative that I believed that could survive even challenges because it's part of the existing law. Okay, so before going into more detail, let's have a reminder. Why can't we fix this mess? Okay. Over the last 20 years, at least 20 versions of the DREAM Act have been introduced into Congress. Everybody likes dreamers. Everybody's for dreamers. But over the last 20 years, there's absolutely been no political will to do anything to have a long-term solution. Okay, so this is a situation that we have. And you know, this is our, you know, our little reminder of the way our government's set up. You know, Congress is supposed to enact laws. Well, for the last 20 years, they've been trying to pass the DREAM Act, haven't been able to. So then you have the executive, the president, stepping up and inventing things. For example, DACA, as much as I love it, it's an invention. And that was President Obama's invention of a way to protect dreamers from deportation. Okay. There was a DACA 2.0, because remember, 2.0 was to be able to allow the younger kids in. Well, that one was killed right away. And then we had, of course, you know, the Biden parole in place, which I'm afraid is going to follow the fate of the DACA 2.0. And even remember that old program, the DAPA program, which never saw the light of day. Okay, so this is why we can't fix this. Okay, so this is a reminder, and I don't know if you can see this, but I've got my little, I voted today. This is why we must be talking to our Congress people. They're the ones that could fix this, but until they figure it out, we've got to see if there's a way around using the laws that we have. Okay. And this is not news to dreamers, but again, we're speaking to employers, and we're also speaking to universities. So it's just a distinction, I think an important distinction. There's different varieties of dreamers, okay? Different flavors of dreamers. You've got the DACA holders, which are the dreamers that we are the most familiar with, because the DACA holders are the ones that actually have employment authorization and protection against deportation. Okay, these are the employees that are usually your number one employees, the top employees. These are the DACA holders. Okay, and those are the ones that I think, according to President Biden's initiative, is that he really went in and actually made changes to the Foreign Affairs Manual, where he pointed out we must, that the consular offices should give some sort of deference or to those U.S. dreamers or dreamers who have U.S. degrees. Okay, so we've got the DACA holders. Next, we've got, you know, the whoops, let me get to this one, DACA holders and the young ones. These are the young kids. These are the young kids that is potentially larger than the DACA population now. And they could benefit tremendously from the D3 waiver path. These are the kids, though, that don't have employment authorization. They're the ones that were not able to actually even file for DACA. So few dreamers under age of 22 hold DACA. Other dreamers who entered after 2007 were never eligible for DACA. Okay, so we've got a lot of young people who actually are really in a rough way, because they're going through school, they're getting their degrees, but they don't have that employment authorization that allows the employers to get to know them. Okay, and that is really a disadvantage. But this is the group of dreamers that's coming up. And of course, then we have the old ones, the old DACAs. These were the DACAs that actually were dreamers. I mean, the old dreamers who were over the age of 31 as of June 15, 2012. These were not, they were too old to qualify for DACA, for the first DACA. And so they're still out there, you know, they're still out there, and many of them are university holders. Okay, so these are the different people that we're speaking to in our webcast. Okay, so let's continue. Okay, so HOPE, the D3 waiver. Is that hope? Let's see, okay? Part of the existing immigration statute offers a waiver of the 3 or 10-year unlawful presence bars, okay? And this, this D3 waiver actually can pardon having lived in the U.S. Over the age of, 18. It can pardon unlawful employment. It can pardon other things. It's actually very broad and very strong, okay? What else do you need? You need a non-immigrant visa, okay? Probably you're looking at an H-1B visa, and we're going to talk a little bit about why that's probably the best choice. The nice thing about the D3 waiver is that you don't need qualifying U.S. citizen or LPR relatives. We do know that we do have the provisional waiver, which is in place now, if for those individuals that are able to show hardship to a U.S. citizen or a legal permanent relative. Well, you don't need this with D3. You don't need this. It's not so complicated and not that time consuming, especially if the administration, and in this case, it was Biden that, said he was going to streamline it. If Harris wins, then she's going to have to be committed to continue to streamline it. And possibly we would have short processing times, okay? They're not there yet. They're not yet there yet, and I'm going to give you a little bit of information of that. But this is why I think the D3 waiver can be hopeful, because you don't need the qualifying relative that's a U.S. citizen or a legal permanent resident. It really will be able to take away that, to pardon those immigration violations, which are the typical ones that we will see that Dreamers have. It has been very underutilized by the undocumented community. And why? There's a good reason. Who is going to voluntarily leave if you don't think that there's a process that's going to bring you back quickly? Okay. And I guess that's the part that's scary about this. Okay. Because at one point you have to say, I'm going to go and apply for a visa. Well, that means that that person's going to leave and they're going to trigger the 10-year bar. So that is why it's not used. Usually, or the times that I have used it is when people are already out, like those students that I talked to you about. It wasn't that I sent them out. I would never do that, but they were already out. They went out by, oops, an accident. So they were out. We were trying to bring them in. We usually see it with people who have been here in the U.S. and have committed a violation and who are trying to come back in, okay? So that's the way we see it. And the undocumented population really don't use it because we've been telling them for years, don't leave, okay? Don't leave. The D3 waiver is the way to come back in legally. And again, obstacles to obtaining residency. And I every presentation I give, I always talk about this. I talk about this because if Congress was so inclined, if they were to change only this part of the law, if they were to take away the 3 and 10-year bars, I bet you that more than 70% of the undocumented people would be able to get status, okay? If they were to take this, and this is a law that came into effect under IRA, the Illegal Immigration Reform and Immigration Responsibility Act. It was supposed to be a mini reform. And so what happened is there was concessions given and certain things given up. In my mind, the only people that benefited from this little reform of IRA were the coyotes, the human smugglers, because they're the only ones that benefited from this law. This law was supposed to stem undocumented entries, but because the punishment was so harsh and was triggered only if you left the U.S., what do you think happened? People stopped leaving. Okay, so people stopped leaving. They came here to work. They stopped leaving, but then they couldn't go see their parents or their children, their families. So what do you think that happened? Do you think they sent the families to go and apply for visas? No. They went to the nice human smugglers, the nice coyotes, paid them $10, $15, $20,000. And what you did is they wanted to reunite their families. So that is all that this has done. And but this is the reason. This is the reason that most dreamers have problems, because all the all the unlawful stay that they've accrued after being here 18 years and 6 months, um, leaving, even if it's leaving to go and apply for a visa abroad, is going to trigger that 10-year bar. So in order to come back in, you're going to need a waiver, and that waiver is a D3. Okay. Um, so let's go on to the next one. Well, what is it you have to prove up with the D3? Okay. And again, under the INA 212 D3 waiver, this is a purely discretionary determination. Okay. So this is based on pure discretion. The case has to be good. The consular officer has to like the case. And that analysis involves balancing social and humanitarian considerations against adverse factors. Okay? So this is what the consular officer does in a case like this. They say, okay, somebody goes and applies for a work visa, H-1B, and that person, well, maybe they were working here, or they were in the country without authorization. They left. They were here for more than a year. They left. They have a 10-year bar. So this is an analysis the consular officer does. It says, okay, what is the risk of harm to society if the applicant is admitted? Okay, so if you've got a dreamer that's got a degree, and they were brought here as children, and they've achieved their degree, they've got their degree, but they can't work. Okay, and the only way they can work, because they don't have a qualifying relative or someone to sponsor them through the family route, would be if an employer were to sponsor them, and they would be granted that D3 waiver by a consular officer. So that risk of harm, if the applicant is admitted, is balanced against the seriousness of the applicant's prior immigration law or criminal law violation. Okay, it actually does even pardon some criminal things. And the reason for wishing to enter the United States. So in the case of a dreamer who came here as a child, who achieved and maybe went and got their degree in medical technology, or in architecture, or in engineering, okay? So the consular officer is going to say, okay, well, what did this kid do? Well, this kid, was brought here, but that wasn't him. That kid was brought here by parents. And what was he going to do? What was the kid going to do? The kid did achieve, despite the undocumented status, the kid did achieve their dream and their degree. Okay, so this kid is now looking and seeking and asking for the discretion of the consular officer to be allowed to enter. Because why? They want to contribute to society. They want to come and work in their chosen career of engineering or medical technology or teaching. Okay? So do you see how that's the analysis that the consular officer is going to make, is saying, what is the risk of harm? What is going to happen? Who is going to be hurt by allowing this person in? Okay? So if the question is, who is going to be hurt if you're allowing a dreamer who came here at a young age, didn't have any say in the matter, who despite that went to school, became productive, and all they want to do is come and work and contribute to the US? Don't you see? That's not such a hard standard. That is something that's doable. Okay? And so This is why I'm hopeful, okay? If the next administration continues to invest money and has the will to streamline this, because currently I would never send a dreamer out, because who's gonna be out there for a year? 14 months. That's too harsh. But if the administration, and again, right now we're right before the election, we don't know what's happening or what's going to happen, but if they were to spend the money here and streamline this and make this doable, this does give me hope, okay? This does give me hope. Okay, so one thing that the Biden administration did do, they upgraded the Foreign Affairs Manual. And the visa office were instructed to consider the fact that a person has a U.S. degree and is returning to work for a U.S. employer, a significant positive factor in meeting one of the D3 requirements, significantly increasing the chances of a waiver approval. If a visa offer declines to recommend a D3 waiver for approval, the applicant can ask the Department of State headquarters to review the decision. That is kind of unheard of, okay? Because usually a consular officer's word, if they say no, that's it. Their supervisors aren't going to come back in. But in this particular update to the Foreign Affairs Manual, there was actually the way to go and approach DOS headquarters to maybe overturn the consular officer's decision. So, this was a nice update, okay? But again, these D3 waivers are never guaranteed. These new enhancements make an H-1B with D3 route faster, easier, and reviewable. For those DACA beneficiaries who choose to obtain an H-1B visa using this process, the risk and uncertainty without obtaining approvals has significantly decreased. This is an essential tool that DACA beneficiaries who don't have the option to or don't have the, the U.S. citizen somebody or resident somebody, this is an option that I think that you can look at, okay? But only if the next administration puts their money where their mouth is, and that's by investing to streamline the process, okay? And this could potentially help the old DACAs, the old dreamers, the young dreamers who are not DACAs, and of course DACA holders. The ones that are going to have the advantage are the DACA holders. Why? Because they have that relationship with the U.S. employer, okay? So anyway, let's continue. Now, the scary thing about the D3 waiver, okay, requires leaving the U.S. You must leave. And again, repeating again that 3 and 10 year bar business. If you've been here for more than a year and a day without status, and you step outside of the United States without the advance parole, we're going to get to that. Then you basically are going to be inadmissible, and you will be facing a 10-year bar, a 10-year punishment. The D3 waiver is supposed to help you cross it back over, okay? So this is what's scary about this, is that's why no one should do it unless we know we have the commitment from the government that's in power to streamline this and to actually make this happen, okay? So that's probably the number one thing that you've got to keep in mind. Okay, so the non-immigrant and waiver process, okay? So again, the H-1B petition employer files an H-1B visa petition, okay? Now, I know that the minute I say this, there's a lot of you that are saying, oh, the H-1B, there's not enough, there's a lottery. Okay, yes, that's true. The H-1B visa, there's only 65,000 H-1B visas that become available each year, plus 20,000 visas are actually set aside for F1 students, right? And yes, there's like a 20% chance that people will make the lottery. Okay, that's true. Okay, and you've got to convince an employer to spend the money on you. Why? Because the H-1B visa classification requires employer sponsorship. The employer has to pay for it, and they are expensive. Okay, so yeah, I got all of that. The H-1B that's subject to the cap is a hard, it's hard to get someone to want to spend money on you if, you know, especially if you're going to need a waiver coming back. However, I would encourage you, for those of you who have your degrees or are about to finish, start looking at the H-1B employers who are not subject to the numerical limitations. Those are the ones that really we should be focused on, okay? And those are hospitals, those are schools, and I don't know whether you know this or not, but the schools right now are facing a terrible shortage. After COVID, there were so many teachers that resigned. Right now, many of the school districts are recruiting foreign national teachers from all over the world to come to the U.S. to teach U.S. Children. So if you're looking at employers who would sponsor an H-1B visa, I think I would focus on those that are not subject to the numerical cap, okay? There are those employers like school districts, some research organizations, hospitals. What they've got to show is that they have got an affiliation agreement with a university, but there are those jobs, and they are in some areas where there's a real demand for employees, okay? So if a DACA holder, if you have DACA, the way to do this, and again, we're not recommending that anyone do it, but here we're just talking about the steps that we would follow, is first of all, find an H-1B employer. If you're a DACA holder, actually apply for advanced parole, okay? Now, advanced parole is that permit to leave and come back without triggering the bar, okay? The good thing about that is that there is now the way to, well, you could actually apply DACA holders for an emergency advanced parole. So if the DACA program is not killed and you've got a DACA person that wants to leave and you know, they've got the H-1B employer, it would be a good safeguard to actually apply for the DACA advanced parole, because if things go wonky, you can still come back in. Okay, that's what it is. It's like a safety to be able to come back in. Again, only available to DACA holders. Okay, so then the next step is leaving the US and triggering that 3 and 10-year bar. Okay, that's a scary part. And then you have to go and apply for the H-1B visa, which will be denied, by the way. Why? Because you're not admissible. Why? Even if you've got a perfect criminal record, if you're 18 years old and 6 months and you've been here for 1 year, stepping out will at least bar you from entry for either 3 or 10 years, okay? So the D3 is required. So you basically would go and apply for the visa, and you would be denied, but then you would submit your waiver packet and say, look, this is why I deserve to have this waiver. And that's when the consular officer is going to do the D3 waiver analysis. And you know, what is the risk of harm to society if you're let in? How serious was your immigration violation? Well, if you were brought here as a child and you had no choice, okay, I don't think that that was very serious. If you work without authorization because you have to eat, I don't think that most consular officers would find that very serious, especially if on top of all the disadvantages that you had, you went and you got a degree. You found an employer that wanted to sponsor you, and you're coming to the US to continue to contribute to society. I think that that's a great case for it. Again, I'm not telling anyone to go and do it now, but this is the way it works. Again, no one should even attempt this until they streamline the process, because right now you could find yourself out for quite a long time. Okay, so what other non-immigrant visa options filed abroad must be compatible with a D3 waiver. Okay, the strongest non-immigrant visa choices are the H-1B. And the reason that the H-1B and the L, intercompany transferee employee, but that one's not very viable. And I'll explain a little bit, but the H-1B does not require you to show that you're coming only for a short time. You can have the intention to come here for a long time with the H-1B. You don't have to show that you're only coming for a little bit. And that's why it's such a good option, okay? Because most dreamers have their whole family here. That's what makes them a dreamer. They've got everything here except for status, okay? So that's what makes the H-1B so powerful. The L1 also has dual intent, but in order to qualify for the L1, you would have to go and work for a company abroad that has a U.S. affiliate that can file Ls, and that becomes a little bit, more complicated, but it's still doable. But it requires you to go and work in a foreign country for at least 365 days, either as a foreign manager or as a specialized worker. Again, a little bit more difficult to find someone to sponsor for that, but that classification has a dual intent. There is a possible choices because the R1 and the O1 have something that's called quasi intent, quasi dual intent, that it might be able to work, okay? But for purposes of this, we're really focusing on the one that I think would be the easiest to try to get, would be the H-1B visa, especially if you go looking for an employer that is not subject to the numerical limitations, okay? So that's that. In talking about what are the major advantages with the H-1B visa, it's the transferring. So it's a two-step process. The first step is pretty. It probably can be done in 45 days. The first step. Okay. Again, dual intent is allowed. So when you go and apply for that visa, you don't have to show the consular officer that you're only coming for a short period. You can have that permanent intent. No need to show a permanent residence abroad, okay? Because by definition, a dreamer can't show that. Their residence is the US, okay? The initial approval is up to 3 years with an extension of another 3 years allowed for not more than a total of 6 years in the H-1B classification, okay? So some of you are saying, well, wait. This is not forever. No, it's limited. It's non-immigrant, okay? Well, you say, well, no, I want to become a resident. I get it. But if you can get a non-immigrant visa classification, then you can actually get an employer to sponsor you for the green card. Right now, as a dreamer, you can't get an employer. You can go and you can have an employer that can sponsor you, but the problem there is that you can't adjust in the US. And why can't you adjust in the US? Because as a DACA holder, you have no status. DACA is not a status. It just is a holder. Okay, all it does is protect you against deportation, and it does, it does give you employment authorization. If you're a dreamer with nothing, you don't have anything. So what you need to do is to get a status, and a status can work itself way into permanent residency in the future, okay? So it's not for residency because an employer can't petition for someone to obtain their residence in the US, and the only way to actually go and try to apply for that afterwards requires a qualifying relative. So that's why we're focused on this. So yes, it is temporary, but if you've got an H-1B visa, then the world will open up to you, because if you've got that employer that actually sponsored you and spent money on you, thinking that you were going to come back, that means that employer, you'd be surprised to find out how willing they might be and they probably will be, to be able to keep you by filing for a green card. Okay, but that's like another webinar. Okay, here we're just trying to get you into status. No, just question. I know we've got some questions coming in. And just go ahead and submit those, and we'll go ahead and see if we can address some of those when we come in. Okay, so what is the H-1B major disadvantage? Okay, you've got to look at everything, okay? It's only available for those individuals who work in professions requiring at least a bachelor's degree or the equivalent, okay? So for all those dreamers that don't have a degree, this is not going to work for you. The H-1B visa would not work for you. This is really focused for those dreamers that have a bachelor's. And so it's only meant for individuals who work in professionals requiring at least a bachelor's degree. Oh, there is a little bit of an exception. Go figure why or how immigration law doesn't make sense. It's actually open to models as well. What models have to do with with bachelor degree holders? I don't know. That's the law, a little wonky. Okay. Major disadvantage, low numerical cap on H-1B visas if you're going for those regular companies. Okay. The idea is to go and search out opportunities with those companies that aren't subject to the numerical cap. Okay. The other big disadvantage is that the expensive filing fees, which must be paid by the employer, and the legal fees. And here, the Department of Labor is really strict with employers. So this is a barrier to entry. This is an obstacle. And you, as a dreamer, are going to have to convince an employer that you're worth the investment. Okay, that you're worth the investment. And naturally, the employer is going to have to see that this D3 waiver has been streamlined, because if not, they're not likely to spend the money to try to petition for you, okay, if they don't see that, you know what, you're going to come back. Okay. So let's continue. Okay. So again, identifying those H-1B visa employers that are not subject to the numerical cap are institutions of higher education, nonprofit colleges and universities. Okay, those organizations that have an affiliation with a a university would be able to sponsor H-1B visa holders. Okay. Governments or nonprofit research organizations, some of those can also sponsor. Nonprofits formerly affiliated with a cap-exempt organization, such as hospitals, public and private elementary schools. Okay, again, these are especially the elementary schools, and well, just, you know, if you happen to be STEM and your degree is science, technology, engineering, mathematics, you know what a school district would do to actually have you go and work for them. Again, this is going to require you to think out of the box. And you know what, dreamers, that's what you've done all your life. You've gone outside of the box, is making those relationships, finding out, you know, going and making yourself available, letting people know how great you are. Okay. And I've seen it. I've seen it happen with, especially with dreamers. Employers go out of their way. If there's a way and they feel that there's a good chance that it might work, you'll find sponsorship. Okay. You know, this is actually one of the questions that I always get. Can I ever be forgiven for triggering the 3 or 10-year bar? Okay. Will the punishment ever be lifted? Okay. Will the bar ever run? Okay. So, you know, the issue is that the unlawful presence bar will be served or satisfied 3 years or 10 years after you left the United States to obtain your H-1B visa abroad. So it, so if you go outside and you spend 10 years out, well, then fine, you're not going to be subject to that, okay? But once you come in and your D3 waiver is approved, the bars no longer apply. It becomes like, you're clean of all immigration violations. If you then qualify for an immigrant visa through employment, you can immediately apply for permanent resident status without an additional unlawful presence rate, okay? So that's what's so powerful about this waiver, is that it takes away all the blemish from that unlawful stay, from the unlawful employment. Actually, like I said, it's actually pretty powerful. It even does pardon certain criminal issues, but of course, Dreamers don't have those problems, so that's another webinar, okay? So it can be forgiven. You can get rid of this, and then when you come in, you're going to be like, a visa holder. Then you can see if you can, get somebody to sponsor you for a green card, or who knows, maybe you find love, and because you have a legal entry as an H-1B with a U.S. citizen person, that you establish the marriage, for good reasons, not to get any immigration benefit, well, then there you are, happy ending, okay? So it can be forgiven, okay? So here, kind of, getting to wrapping up, there are 3 potential outcomes for DACA beneficiaries, okay? Again, sorry, this is for DACA beneficiaries because we're focused here on DACA beneficiaries because they're the ones that have it a little bit easier, but we'll talk about the others. Younger DACA beneficiaries under 18 years and 6 months, okay? So let's say that you got DACA when you were 15 years old. And every year or every 2 years, you've been extending, and you have no more than 180 days of unlawful presence, guys. When you leave and you apply for that visa abroad, you will not trigger the unlawful presence bar, okay? So we've got because we've been urging our DACA clients to do something. For some of these DACA people, because they got DACA so young, they don't have 180 days of unlawful presence. So those kids are actually leaving the US and going and applying for the H-1B visa. They don't have inadmissibility. They're able to come back in. Okay. What is true is that consular officers still get a little bit queasy, and we have to work hard as attorneys to make sure that the consular officer knows that this person is admissible. And so we'll, but this is actually happening now. It's happening as we speak, okay? And this is the best case scenario because you don't need a D3, because you don't have unlawful presence, because you don't have immigration violations, okay? But it does require you to really have an employer that wants to spend that money and really wants to bring you back in. So that's one of the best outcomes. Again, that would be for those and younger. Why? Because any time spent outside of any time unlawful presence spent after 18 years and 6 months, it starts counting. Okay, and that's a problem. Okay. So in that case, the DACA application was approved before you turned 18 years and 6 months, and you don't have more than 180 days of unlawful presence. Again, here, you're going to want to make sure that your I-821 receipts are handy to prove that you don't have more than 180 days of unlawful presence. Okay. An H-1B visa will be issued with no finding of unlawful presence, and no D3 waiver is required. Okay. Caution here. Even in this case right now, we're having to work hard to make sure that the consular officers don't think that that you need a waiver. Okay. The other DACA beneficiaries, even those with approved applications after they turned 18 and 6 months, issued an H-1B without a 212 D3 waiver. Now, I don't think this is very probable, because here you're going to have to convince an officer that you don't really need a waiver, okay? Why? Because you left the US with the DACA approval maybe a DACA advance parole. And so what you're going to have to explain to the officer, look, I left, but because I left with a DACA advance parole, I really didn't leave. Okay, so I don't need the waiver. Since I didn't leave the waiver. I don't really see that this is very viable, but that's one of the things. Again, if this happens, the H-1B visa will be issued with no finding of unlawful presence and no D3 waiver is required. Okay, again, I don't think the consular officers would buy it. Okay, I think that, but anyways, that's an argument that can be made. And the third option is older DACA beneficiaries who were issued an H-1B visa with a D3 waiver. The visa officer must often or will require a DACA beneficiary who applies for an H-1B to obtain a D3 waiver after finding that traveling on DACA advance parole still triggers an unlawful presence bar. So let's say that you do have, let's say that you actually do, you get advance parole anyway. This is probably, I think, the most likely outcome is I think that the consular officer will say, well, that's great that you have advanced parole, but you still need the D3 waiver. I think this is probably what would happen. Okay, but this would be great because let's say you've got an older DACA person, you've got the employer, and the employer got to know you because of your DACA employment authorization, and you were able to convince them to spend the money on you. It doesn't matter that you have 10 years of unlawful presence. Okay, the D3 will cure 181 days or 100 years of unlawful presence. That's what's so powerful about the D3. Okay, so in preparing for the immigration examination, okay, this is what an immigration lawyer is going to want to know. Were you inspected upon arrival? Okay, do you have evidence of inspection? If you enter without inspection, where and how did you enter? How old were you? Has anyone ever filed a family or employment-based petition on your behalf of your mother and father? If so, when? Now, this becomes very powerful for those people that might have a petition filed on behalf of their parents. Maybe it was a brother that filed for your mother or father before April 30th of 2001. If you're so lucky to have one of those receipts, and again, this was a receipt that your aunt or your uncle might have filed for your mother or your father, okay, you can use that benefit to actually adjust your status in the US. And actually, that was kind of the conversation or the webinar that Marisela Alvarado presented, and they talked about kind of combining different aspects of immigration law to kind of find a good outcome. Have you ever been deported? Okay, this that is important to keep in mind. Have you ever been deported? Because there's another analysis that has to be taken and probably should be done before you move forward on this, okay? This is not something that you should rush into doing it. Why? Because even though they said they were going to streamline, they really haven't yet, okay? But this is hope that if we get the right administration in the White House, that maybe they will really streamline it and make this a possibility for dreamers. Okay, you're also going to have to be able to explain or find out if you've ever traveled outside the U.S. on advance parole, in DACA parole. Okay, so what is it that you can do? Okay, so now I've gotten you all excited, and you say, okay, sign me up. No, you're gonna have to cultivate the relationship with the employer, because remember, that employer is going to spend about $5,000 or $6,000 on you, believing that you're going to come back. Okay, so update your resume. If you're not working in your profession, keep active through associations. Sign up for research. Keep active in your profession. Consider volunteer work to enhance professional profile. Let's say that, again, plug for those school districts. Let's say that you're trying to get someone to sponsor you. Go and volunteer in the schools. Volunteering is free to anyone. You don't have to have status, okay? And also, DACA grantees have all of your receipts ready, okay? So we've got maybe 1 or 2 minutes, and one of the questions that I'm hearing here is, could you please explain how the O1 can be used to get a D3 waiver? Sure. Okay. The O1 is kind of a fancy, and I'm pulling back here. It's kind of a fancy status. That the O1 is the Extraordinary Ability Visa. And these are for people who are superstars. I actually did work on a O1 Extraordinary Ability D3 waiver. It was actually a person who was a big music star. I don't know, he was very famous in his music. And so what he did, he had been brought to the US as a young child, but he wanted to go abroad. So what he left and applied for the D3. He was able to prove that he was extraordinary, okay? And there's criteria that has to be met. And again, he was like a Grammy winner and lots of things. And then he was able to show the consular officer the good he was going to come to do was going to outweigh the fact that he was brought to the US as an undocumented child. And he did. He won his visa. He got his waiver. He came back in, and that was a happy ending. Again, that's what the extraordinary ability. And you know what? I bet you there's some dreamers out there that do qualify. And you know what? So, but this one is quasi dual intent. So we'd have to work out some little, the safest one is the H-1B, okay? But there is quasi dual intent with O1. The religious worker also has quasi work intent issues, okay? Okay, we're just about finished. We're just about finished. And so again, send me an email. You want to find out more about this. Let's see what happens with the elections. All of you have US citizen people that you're close to. All of you can encourage them to vote for that party that's going to keep your interests in mind, okay? So anyway, guys, thanks for your attention. I know I promised I would leave at 6 on time, but if you've got any questions, send them and I'll respond, okay? And stay tuned. We're going to be having another webinar soon that will talk about the dreamer situation, okay? Thank